Hi, my name is Arlene Smith Scott. I'm an attorney with Strategic Law Group. We specialize in foreclosure defense work. Part of that includes handling foreclosure mediations. Now, the subject of this video today is why post-filing foreclosure mediation. And our subject again is why post-filing foreclosure mediation. I have clients come to me when they're facing foreclosures, and the first thing they're saying at the mediation, I'm going to go before the judge and I'm going to tell the judge everything that went wrong, and I'm going to let the judge know that my lender didn't treat me in a fair and equitable manner. And it's always hard to be able to sit down and explain that in a foreclosure mediation here in the state of Maryland, it really doesn't quite work that way. Even though we have technically a judge that is overseeing it, it's an administrative law judge. And the sole purpose of the administrative law judge is to determine whether or not an agreement has been reached between the parties. And generally what happens is you go into a room, you have the administrative law judge, you have the attorney for the opposing counsel or for your lender, and you have a phone in the middle of the desk, and then you and your spouse may be there. You and your spouse with your lawyer may be present. And what happens is more of an information gathering session to help you determine what's available, and then an opportunity to see where you may fit. But prior to the foreclosure mediation, you need to understand a couple things. You need to ask yourself first, have you filed a request for mortgage assistance? The reason why it's so important to file that request for mortgage assistance, it gives the lender an opportunity to see where and if you qualify for one of their programs. So what I want to do today is I want you to know what the basis for, because foreclosure mediation wasn't always mandatory in the state of Maryland, nor is it mandatory for investment properties. It is only aimed at owner-occupied properties. And what happens is, because there's a couple different steps in the process, the request for post-filing mediation generally begins when you receive the final loss mitigation affidavit from your lender. In that package, it should include two envelopes, an envelope for the court and the envelope for their office, and two requests for foreclosure mediation. You send it back in to the clerk of court for circuit court for the county that you live, and you send it with a check for $50. Then you send the other one over to the lender so they are also aware that you sought and you're seeking foreclosure mediation. The clerk of court will then contact the Office of Administrative Hearing and say, hey, this is the date, and put you on the schedule and notify you of the schedule. Now, at the foreclosure mediation, people ask me, why do I need an attorney? Why is it important to have legal representation at a foreclosure mediation? Well, the first thing is when your lender has an attorney and has the legal resources, that this might be the best opportunity for you to have an attorney who's familiar with the mortgage process. Why? Because if you filed a request for mortgage assistance, that attorney who's familiar with the mortgage program will help answer several questions. First, if there's an arrearage, and clearly you must be in default, or they must be arguing that you're in default, how much are you in default? How did they arrive at that number? Then, what is your principal balance? You have negative escrows? Do your escrows include taxes and insurance? Is it only homeowners insurance? Is it also mortgage insurance? Did they put forced place insurance? So these are questions you need to determine at that time. The next thing is you need to also be able to understand what programs are available to you. Now, many people think, oh, all the lenders offer the same programs. That is not true. You may have one lender who offers a HAMP 1, HAMP 2, a waterfall program, which is their in-home modification program, and some of them do not. So you need to find out what's available to you. Then you need to find out, did you meet the requirement? What is your loan to value? What's your house worth? How do they know your house is worth that? Did they do a broker price opinion? Did they have a drive-by? Was there an appraisal done? The next question is, how are they valuing your income? So for example, if you get rental property, are you using 75% of your lease amount? Are they using your Schedule E from your federal tax returns from 3 years ago? How are they arriving at your income? So what programs are available is extremely important based on your income. The next thing is, when people are thinking of litigation options, what are the litigation options? People say, well, Arlene, what is a deed in lieu of? Well, if you only have one mortgage, a deed in lieu of is simply this. I'm going to give you the deed. I'm going to save you the opportunity or save you the hardship from foreclosing on me. You might have what's called a cash for keys program. Yes, they will help pay to get you out of the house, but it depends on what part of the process. Are you at the very beginning? Are they already foreclosed? Where are you in the process? Okay, and what does your lender have to offer? Also, one of the questions is, do this lender have standing to even foreclose? People might say, well, don't the mortgage company knows? A lot of times you have hidden entities that have purchased notes, so it's not heavily defined. So, why foreclosure mediation? First is information. 2 is understanding who's before you. And 3 is giving you additional time to seek modification or try to get a job that's going to bring the income that's needed to allow you to qualify for some alternative program like a modification or maybe even a refinance. My name again is Arlene Smith-Scott. I'm with Strategic Law Group. We're in Bowie, Maryland. Our website is www.slglegal.com. Please visit our website or please give us a call. We'd love to help. Thank you.